Hello, everyone. Welcome to our ninth webinar. Today we have with us Mr. Rajeev Virmani, Senior Advocate. I know Rajeev sir personally. I've briefed him in a couple of matters, and I can say that he is one of the finest persons and tutors or mentors to teach us what we're teaching today. It is the drafting of affidavits and evidence, challenges and solutions. Today, he's not going to talk about the civil procedure or the aspects of the provisions under law. He'll actually talk about the practical problems that all of us face as young lawyers, old lawyers, budding lawyers, when it comes to drafting of affidavits and evidence, which is the key to any civil or commercial law case. I am Gaurav Goyal. I'll just introduce myself. I am a very young practitioner. I run my own small law firm by the name of JKGA Law Chambers. I am a certified mediation advocate and advisor, and I'm also a member of the Chartered Institute of Arbitrators. Our co-host today, our co-moderator today is Ankit Virmani. I know Ankit since I was an intern at Wadia Gandhi at Mumbai. He was my principal associate then. Back then, I did not know the association like that. He was Rajeev Virmani sir's son, but Ankit in himself is a fantastic lawyer. He's young, he's dynamic, and he, along with Rajeev sir, I'm sure will teach us today a lot. So we're switching on to, we are at 100% capacity. We'll be starting right on time. Ankit, on to you. Can you introduce yourself?
Thank you, Gaurav, for the kind introduction. Hi, everyone. I am a litigator, a very young litigator, I would think, with only 10 or 11 years of experience, which shows that I really need a lot of learning still to go. I have been learning a lot from my father, Mr. Rajeev Virmani, for the last several years on various aspects of legal strategy and the law itself. One of these areas is trial law, and this session as well as the next session is where we will focus a little bit on the affidavits and evidence as far as this session is concerned, and cross-examination in the next one. I'll give a brief introduction about Mr. Virmani before we start off. After getting a gold medal in his LLB degree at the Agra University, he came to Delhi and started practicing with Khaitan and Company in the year 1981. He started out on his own in 1983, and he soon after that became an advocate on record in the Supreme Court. In 2002, he became part of an advocacy skills training program in India. This was initiated as an Indo-British project in which he was trained as a lead trainer, and he has now gone on to train thousands of lawyers. The statistic I have is somewhere more than 6,000 lawyers have been trained by this team of which he's a part in the Supreme Court, various high courts, around 9 high courts across the country, the TD SAT, various district courts, etc. He's been also a senior mediator at the Delhi High Court Mediation Center since the inception of the center in 2006. He was designated as a senior advocate in 2009. After that, he has also done an advanced leadership program at the Oxford University in the year 2016. Now, as a senior advocate, his area of practice is commercial litigation. He's regularly briefed in high-stake matters, including in IPR matters and arbitrations involving shareholders' disputes, disputes pertaining to construction contracts and various other kinds of matters. He often gets briefed for trials, final hearings as well, even if he has not been briefed at the initial stages. And therefore, trial is one area where he has special expertise in. Now, in the last few years that I have worked with him, I used to be in Bombay earlier, where I met Gaurav long time ago. Having moved to Delhi a few years back, I've been working with him, had the occasion to brief him in several high-stake matters. And what my colleagues friends across the bar, and what my own experience says is that he's extremely thorough in his preparation. He is not only thorough himself, but he keeps you on your toes also. And uh, one aspect, which is what we're touching on right now, which is settling, or which is affidavits and evidence. When he sits down to settle an affidavit and evidence, it's great to see him apply the basics to even complex problems and fact situations. Now, coming to the topic at hand, affidavits and evidence. Uh, in law school, we don't really learn how to prepare an affidavit and evidence. At least we did not when I was in law school. I'm not sure about how the situation is today. While we learn the provisions of the Evidence Act and the CPC, etc., we don't really learn the practical aspect of it. And as a young lawyer, therefore, it is important for us to understand these practical aspects. Who should be a witness? What you need to write in an affidavit and evidence, what you don't need to write, what you should, how you should prove a document, and things like that. I have seen a number of affidavits and evidence which are replicas of pleadings, etc. And those can, not only do they not serve any purpose, they can also be counterproductive, where your credibility of your witness can also come under question. So with this introduction of the speaker and the topic, I'll hand over back to Gaurav.
Thank you, Ankit. I just have quick instructions before I go on to Rajeev sir to take on the session forward. Everyone, please pin Rajeev Virmani sir's video so that you only see him and his screen all throughout. Also, I request everyone to stop their videos and keep themselves on mute. Thank you so much. Rajeev sir, on to you.
Good evening, everyone. Welcome to this session on affidavits and evidence. Let me assure you, it has got nothing to do with a particular legal provision saying this, that, etc. for you. No, it's all about a skill. When we go about our business of drafting an affidavit and evidence, how do we go about it? What are the things we should really keep in mind when we sit down to figure out, who the witness is going to be and what is it that the witness is going to really speak about? So these are some of the very important aspects which I thought I must share with you in this talk that I'm going to present to you. I'll be sharing with you on the screen a small PowerPoint presentation, and I'll take you along that presentation and tell you what I wish to convey as I move ahead with the slide. So I'll just put that slide on the screen. Ankit, do you have that presentation? Can you please share it somehow? Or Gaurav, if one of you can please share it.
Sharing, sir.
Thank you. So, friends, let us understand what is an affidavit in evidence. Why is it that we need to think about affidavit in evidence? As you all know, there was a time when we would be presenting our witnesses, would be standing in the court, and we would ask them questions, and they would answer, in an oral examination in chief. So to speed up things, it was thought that it's best that if you are producing your own witness, you file his affidavit and evidence so that the court's time is cut short. And of course, it gives you an advantage of preparing something, beforehand in your chamber. So Gaurav, can we please move to slide number 2? Yeah. So oral examination in chief of a witness, when it is reduced in writing, sitting back in the comfort of your chamber or your office, we call it an affidavit in evidence. And we file it because it is now permitted to be filed in the civil proceedings and in arbitrations. The advantage is the court's time is saved. You can think about what you want to say. And of course, you can prepare well and present a comprehensive affidavit. To the contrary, when you are appearing in the court and examining a witness orally, it's possible that some aspects may be left out when you are presenting your evidence, or the witness may not be in a position to state what you want him to state. So it has certain advantages. Now, gaining those advantages, it is important that you don't lose those advantages. So it's important to know what is it that goes on into making an affidavit in evidence. If Gaurav, can you please move to the next slide? Yeah. So the question that arises is, why do we need to file an affidavit in evidence? You need to file to prove the case of your client that is in contest. Now, when you file a case, when you file a plaint or a statement of claim in an arbitration, you would have realized that there are things which are admitted, there are facts which are admitted by the opponent, and there are facts which are denied by the opponent. Now, the facts that are denied, you need to prove them if you are the plaintiff, because if you don't prove those facts, you may not get the relief that you are seeking from the court. So that's one aspect that it serves. The second is, you may have filed certain documents with your plaint or with your written statement or with your statement of claim or statement of defense. Some of these documents are denied by the opposite side. Now you must prove those documents. How do you prove those documents? By leading oral evidence. So there again, the affidavit in evidence is the tool in our hands to prove those documents which have been denied by the opposite side. So in other words, what we really need to do, as you know, under the as far as leading evidence or the purpose of evidence is that we need to prove the existence or non-existence of a particular fact that is relevant or a fact which is in issue. So that's the purpose why we file an affidavit in evidence, to prove what is in issue, to prove a fact, whether through a documentary evidence or through oral testimony of a person. But we now reduce it in writing in advance and file it in the court. So that's the purpose it serves. Can we have the next slide, please, Gaurav? Now, you'll ask me a question. We have filed a plaint, we have filed a written statement or a statement of claim. Is it not sufficient? Answer is no. Because in pleadings, you don't plead evidence. In pleadings, which are plaint, written statement, etc., you only set out facts in support of your client's claim. They are not supposed to contain evidence, and certainly they are not the proof. They only, for instance, I'll give you an example. If you filed a case, you can say that yes, parties have arrived at a contract on a given date on 1st of May 2020. This contract was arrived at by exchange of correspondence. There were 3 letters exchanged between the parties. One on 20th April, one on 25th April, and the third one on 1st of May 2020. And the effect of these 3 letters is that a contract has come into existence. Now, you may plead that yes, through correspondence by exchange of 3 letters, a contract has come into existence. You may state in brief that these letters were exchanged. But what if the other side comes forward and says, sorry, there was no contract between the parties. We were still negotiating a contract. Now, therefore, there is a dispute between the parties. Whether a contract has come into existence or not, whether there was any correspondence, if it is denied, was exchanged between the parties or not, and whether this correspondence has the effect of creating a binding contract between the parties. So pleadings are not really proof. You plead. Other side responds. And once the other side has responded, you will realize that there are facts, there are allegations which are disputed. So now, what is disputed and which is required by you to be proved is proved by leading evidence. So pleadings set out the game. Pleadings set the ball rolling. But the next step after pleadings is you need to prove what is in contest, what is in dispute. So therefore, we lead evidence. So Gaurav, can we have the next one, please? Now, once you realize that we have to prove certain facts, the question arises, how to select what we need to prove. Now, you would have seen, as Gaurav and Ankit mentioned, that in certain situations, some people think the easiest way is to copy paste the pleadings. I have seen cases where affidavit in evidence is nothing but a complete reproduction of the plaint or the written statement. Plaint right down to the extent of mentioning court fee, jurisdiction, cause of action, etc., and even prayer. Now, that is not really correct, because pleadings, as I mentioned earlier, are not evidence. And copy pasting pleadings is not the right way to go about when you make your affidavit in evidence. So how do we go about it? So look at the pleadings. When the stage comes for drafting affidavit in evidence, you have your pleadings, you have the opposite side's pleadings. Just compare the two, para by para. You will realize that there are certain facts which have been admitted by the opponent. Now, the law is very clear. Facts which are admitted need not be proved. So you don't need to labor upon those facts which have been admitted, because the law says that they need not be proved, because the court will look at those facts as an admitted position between the parties, not as a position which is in contest between the parties. So please remember this. You need to sift through the pleadings. You need to filter through the pleadings to understand what is admitted, because whatever is admitted is not really required to be proved. So that's first step. You will understand. That's the first exercise you need to undertake. Then you need to look at the issues that have been framed by the court. Now you realize that whether you are in a court, civil court, or in an arbitration, the issues or the points of determination are framed by the court. They set the agenda for what is it that the court has to decide. So look at the issues. See what are the issues. What is it that is required to be proved? And that will also set the tone and agenda for what is it that you need to say in your affidavit in evidence, or what is it that we need to prove really. Having done that, there is another exercise you need to do. Look at the admission denial of documents and see what are the documents that have been denied. And if they have been denied, you need to make efforts to prove those documents. And again, the opportunity is to file an affidavit in evidence. Having done this exercise, now comes the next challenge. If you are in a commercial litigation, for instance, you will realize that in a commercial litigation, it is not as if there was only one person from your client side who was dealing with the opponent. There could be two, there could be three, or there could be four persons, or there could be three departments who were dealing with that transaction at different stages. Maybe there was a team which was there at the stage when the contract was being negotiated or signed. There was another team which was involved in implementation of the contract. There was a third team which was involved when the disputes arose. So now there are three sets of persons, each one having played a significant role at a different stage. So important thing is identify what are the different topics which are involved in the disputed matrix that you have identified. There could be one, for instance, Gaurav, if you can please move to the next slide. Yeah. So you would have assessed the role of different persons who would have dealt with or have competence on different chapters. Once you have identified them into different chapters, somebody would have dealt with the finance, somebody would have dealt with the commissioning part of a plant, somebody would have dealt with the accounts related dispute. Now, once you have identified the disputes or the disputed arena and classified them into different chapters, you will now know who is the right person to depose on that particular aspect. Let me tell you, a person who has dealt with the commercial aspects of a problem is not the right person to speak about the technical aspects. See, अगर किसी ने कमर्शियल एस्पेक्ट पे डील करा है, वो कैसे बोलेगा whether the plant was commissioned properly or not? How can he say that that there were any defects in the goods which were supplied जब उसके पास वो technical qualifications ही नहीं है? Or for instance, if there is an accounts related problem, you can't produce an engineer. वो engineer आके कैसे कहेगा कि accounts में ये entry हुई, ये पैसे आए, ये पैसे नहीं आए, और this is the financial dealing between the parties, because he's not concerned with that aspect of the business. So therefore, it's important to identify who is the first, having put them into two or three or four baskets. You know, your disputed facts, you would have put them into 2, 3, 4 baskets. Then the next thing is assess. कौन सही आदमी है, कौन सही व्यक्ति है to speak on a particular aspect, you know, and you can do it by talking to the clients. Get the clients over, talk to them. And let me tell you, talking to one representative of the client, you know, in case it is a company or in a large commercial contract, may not be good enough. You need to get the team together. And when you start talking to the team, तब आपको पता लगेगा कि भाई there are different people who are, you know, responsible for different aspects. You know, there is domain knowledge, as we call it, which is available with different people. So, you know, what is important is that you choose the person who's conversant with the topic. Remember, हम affidavit बनाते हैं, उसमें क्या लिखते हैं? I so and so, I am the general manager of the company, and I am conversant with the facts deposed to. Why do we write conversant? If the person is not conversant, why should he write that? So please remember this. इसको ध्यान रखना है कि जो conversant है, उसी को witness बनाना है. Person who is not conversant will never be a good witness. He'll falter in cross-examination. And you know, once you have made out a team of, let's say, 2 or 3 witnesses, each one speaking on a different aspect, everybody would have that comfort that I am speaking in a domain or on a topic where I have the knowledge, or where I know, you know, what is it that I have to speak. And therefore, he would not have that, you know, that fear at the back of his mind कि अगर मुझसे किसी दूसरे सवाल किसी दूसरे टॉपिक पे पूछ लिया तो मैं क्या जवाब दूंगा. Because, you know, as lawyers, we don't sit in the chair of a witness. But think of it, you are sitting in the chair of a witness. There are apprehensions in your mind. You don't know what questions are going to be asked, how uncomfortable those questions would be, what answer would you give? Because witness जो है वो रोज सवाल जवाब नहीं करता है. Of course, घर जाके करता होगा is a different matter, but once you reach home, you have to give many answers. But when you are sitting in the chair of a witness, there are a lot of apprehensions which are in your mind. So important thing is choose a witness who will feel comfortable on the subject that he has dealt with. The next, you know, sometimes ये कहा जाता है कि चलो 2 witness रख लेते हैं, एक ने कुछ गलत बोला तो दूसरा संभाल लेगा. In my view, that's a wrong strategy. You talk to the witnesses in advance. If there are 2 people on the same topic, you know, keep only one. By talking to them, who's more confident, you know, who would be in a better position to answer, usko select karo. And you know, once you have done that, then you know, you are confident that yes, I have one person on a topic, and he would be in a position to, you know, the rigors of a cross-examination. So Gaurav, can I have the next slide, please? Yeah. So having done this exercise, so what we have done so far, we have seen what are the admitted facts, the disputed facts, what are the issues, what are the documents. Then we have divided the entire thing into 2 topic wise. We have identified for each topic, and then we now sit down to draft the affidavit, right? So how do we go about it? First, affidavit has to be a first person account. I say so and so. It can't be plaintiff says so and so. Because plaintiff, if it is a company or a partnership firm or another entity, is not stepping into the witness box. Individual who is stepping into the witness box. So it has to be a first person account. You then talk to the witness, interview the witness, discuss the topic which is there for his testimony. Once you start discussing with the witness, you will realize that how simple things are, how simply he's explaining to you कि देखिए इस दिन ये हुआ था, मैंने ये चिट्ठी लिखी थी, उसका ये जवाब आया था, उसके बाद इन्होंने कुछ करा ही नहीं, सो गए बिल्कुल प्रॉब्लम को लेके, वो जवाब ही नहीं दिया 3 महीने तक. He would be in a position to explain to you because he's the one who has gone through that crisis, who has gone through that problem. So interview him, understand from him what is he saying. That will help you write down his story. Because please remember, it is that witness whose story is going to be presented to the court. It is not the of the lawyer or the advocate that is going to be presented to the court. So having interviewed the witness, having understood his perspective on the scope of his testimony, you give introduction of the witness in your affidavit. What is he? What are his qualifications? What is his experience? Uska kya role hai company mein? Because this will set the agenda for him and also for the court to know that yes, he is the person who's relevant for this topic, who is apparently conversant with the facts that he's deposing about. Because unless the witness court is convinced that he's conversant, court will say, "Ye to suni sunai baat bol raha hai, hearsay bol raha hai." So it's important for you to give, his experience, his role, how he has dealt with that problem, about which he's speaking. If it is a company witness, then you must produce his authorization because he is ultimately speaking on behalf of the company. So there has to be an authorization. Please annex a copy of his authorization. Identify that part of transaction in respect of which the witness is filing the affidavit and how he's conversant. I've already spoken about it. And then, when you are asking him questions during interview, you have a complete chapter to cover. But my suggestion is, please divide that chapter also into sub-chapters so that you build a story brick by brick. You build a story which moves, like when you read a good novel or a good book, you finish one chapter, you move to the next chapter, it makes very good reading and you're very happy when you have read it. Similarly, if you're in your affidavit in evidence, if you can present a picture which is coherent, which flows well, even the judge will enjoy reading it because ultimately that evidence is being presented to the judge. And if it is presented in a manner which moves seamlessly, which moves from chapter to chapter, judge will be very happy and it will be convenient for him to understand what you want to tell him. So now, can you please move to the next slide, please, Gaurav? So the witness, it's important for you to remember when witness is speaking about the facts, he talks about the facts which are within his knowledge. If the facts are within the knowledge of another person and the witness is attempting to speak about these facts, other side will raise an objection that this evidence is hearsay evidence. And as you know, hearsay evidence is not admissible. So his testimony to that extent will be discarded. So let's not, get into an area which is going to create problem for us. Therefore, witness must speak about the facts that he knows from his knowledge. Or sometimes a witness can also speak from the records of the company. For instance, account books. A witness can speak from the account books of the company if he's the accountant of the company, because he knows those books of account are being maintained in the normal course of business. He's supervising the book writing, or he's the head of that department. He knows that they are being regularly audited and maintained, etc. He can then say that a particular statement of account is based on the records which are maintained by the company, and that he believes to be correct. It's important, believes to be correct. Please remember, one is true to my knowledge, the other is what I believe to be correct. So there is a distinction between these two. Please remember this. Now, there is another aspect I want to touch upon. You know, sometimes in drafting affidavits or in pleadings also, we have paragraphs which run into not one but couple of pages. Now, in my view, that's my personal view, that's not a good idea. You must keep your sentences short. You must keep your paragraphs short. They read well, they convey well. If your sentence is long, the meaning may get lost by the time you finish reading the entire sentence. If your paragraph runs into one full page, you may have said too many things in the same paragraph. It's just a good habit, good idea to break that long paragraph into 2, 3, or 4 paragraphs so that whatever story you want to convey, it gets conveyed in shorter paragraphs, each paragraph conveying one fact. So, you know, we say, set out one fact at a time. Never mind if your paragraph runs into 3 lines, that's okay. Nobody says that your paragraph should have at least 10 lines. But once it's a short paragraph, it conveys one idea or one fact, it reads well, it registers well. So please remember this. Now, the next thing is language. Please keep the language simple. Avoid using legalese. I'll tell you why. Your witness is not a lawyer and he doesn't understand that legalese, let me assure you. He may pretend that he understands, but he doesn't. Because in his day-to-day life, he is not dealing with that legal language. I'll give you an example. I was cross-examining a witness once who had used in his affidavit an expression which we as lawyers use every day, inter alia, right? I know all of you know the meaning of inter alia. But just to test that witness, I asked him, I said, do you know the meaning of inter alia? It took him 20 minutes or more maybe. He kept struggling, but he could not answer and sought an adjournment. And we never saw that witness again. They withdrew the case because that affidavit was full of legalese and legalese that the witness, the jargon witness could not understand. So let us not make life complex for our witness. Let us make life simple for him. Write the affidavit. You are the lawyer. You have to draft the affidavit. There's no choice because now that's a liberty which is given to us. But while making use of that liberty, keep the language simple. Language ऐसी रखिए जो witness को समझ में आ सके. You know, he can understand that simple language and say, हाँ मैंने बिल्कुल ठीक बात लिखी है. मैं ये समझ रहा हूँ. Because अगर language उसकी simple होगी, तो जो cross examine करेगा, वो भी उसी language पर cross examine करेगा. You know, the witness would be in a position to answer that question better. Now, can I move to the next slide, please, Gaurav? Yeah. So having reached this far, where you have seen what the witness is going to depose about as far as his knowledge is concerned, you will realize that there are documents which have been denied and you need to prove those documents. Then you need to exhibit those documents. Now, again, when you are selecting those documents, you divide those documents again in the same chapters. Like if your story is divided into 2 or 3 chapters, allocate documents to each chapter so that, you know, if a person is speaking on the commercial aspect, he will have the documents relating to commercial aspects to be proved that he is familiar with. He will not have to deal with the documents on the technical side that the technical person will speak about, because ultimately, if a witness is speaking about a document, he's exposing himself to be cross-examined on that aspect as well. So divide the documents again into the same baskets, into the same chapters. As you know, and as I said earlier, I'm not taking you through the legal provisions because that's not the scope of this webinar. You need to prove documents by primary evidence or secondary evidence. Primary evidence is the document itself, and you know what are the secondary documents. It's all laid down in law, you know. something which is not an original, something which is produced by a mechanical process, or you know it already. If you do not have primary evidence when you have to make an exhibit number, then please lay the foundation for leading secondary evidence. And law lays down very clearly what are the prerequisites before you can lead secondary evidence. So please keep that in mind. You just can't say that copy of so-and-so is exhibit so-and-so. It may not be allowed to be admitted in evidence. You will have to first lay down the groundwork, whether the original is in the possession of the plaintiff, you or the opposite side, whether you have given him a notice to produce the original, and then you are leading the secondary evidence of that document. Or if it is your case, कि original तो गुम हो गया, original मिल ही नहीं रहा है, then you have to show कि original कैसे गुम हो गया, what steps have you taken, and then you lead secondary evidence. But important thing to keep in mind is कि secondary evidence lead करने से पहले, please lay the foundation for leading secondary evidence. Don't take it as a matter of right कि कोई बात नहीं, primary नहीं है, secondary चलेगा. ऐसे नहीं होता है, right? Now, nowadays you realize that a lot of evidence that we get is in the form of electronic record. And all of you are familiar with it. You're watching a webinar, so you know what electronic record is. And law lays down certain requirements for leading secondary evidence, proving and exhibiting electronic record, whether they are in 65B of the Evidence Act or under the Commercial Courts Act now. CPC is amended. I've just mentioned briefly those provisions so that you please keep them in mind. They are very important. How electronic record has to be proved before the court. So please don't miss out on that. Right? Now, keep in mind one more thing, and I can tell you from a practical experience. I was cross-examining a witness where he had himself certified certain electronic records saying कि मेरा laptop model ये था, Canon का था, और मेरा printer HP का था, and I printed, I did this, that, etc. And I felt somehow that he was lying. So I asked him कि भाई, you are a director in the company. Yes. Do you have a private secretary? Yes. आपकी सारी जो correspondence है, emails हैं, वो आपकी secretary ही print करती है. He said, yes, I have got 2 secretaries who printed. तो I asked him कि even जो आपने affidavit के साथ सारी emails लगाई हैं, आपके secretaries नहीं print करी होंगी. He said, yes. So now see what is the effect. In the affidavit, he had said, I have printed from my Canon laptop, HP printer, this, that. All that stood demolished because it was proved that he had lied. So remember, if the witness is going to prove those documents, then ensure that he has printed, he has downloaded and printed it himself. Don't leave it to a third party to do it. Don't think that your office will print those documents and witness will say, yes, I have printed these documents. This can, this may look very innocuous to witness. He may not remember, what has happened. But yes, the other side lawyer, when cross-examining your witness, will really have a field day. So this is something which is clearly avoidable. Please remember it. Sometimes, we are caught in a situation where the person who has signed the document is not available, he has left the company, etc. So when proving a document, if the witness is a signatory and the other side has denied the document, witness can of course say that I have signed this document was dispatched from my office, whether dispatched by courier or by speed post or by whatever means. He has to lay the foundation for everything to show that yes, he's the author of the document, it was sent to the opposite side, and if there is a POD available, here is the POD. Now, if he's not the signatory, but he knows or he has seen that other person who has signed the document to sign it on different occasions, then he must say that yes, this document is signed by Mr. So-and-so, who's no longer available with the company. I identify his signatures because I've seen him write and sign. It's important to say all those things. Don't take it for granted that you can simply say, letter dated so-and-so, sent by the plaintiff company, is exhibit so-and-so. Let me assure you, opposite side will raise an objection. Document may not be admitted in evidence. So Please remember, these are very important things to keep in mind when you are drafting your affidavit in evidence. So Gaurav, can we move to the next slide, please? Yeah. That takes us to the next part, which is, the last part of the affidavit, where I have seen people pay the least attention. It is a verification. They just say, yeah, no, verification type kar dena. They'll leave it to the steno, to the clerk, or to somebody to just copy paste verification and just type it. No, that is wrong. Verification is required to verify what para of the affidavit is true to the knowledge of the witness, what para of the affidavit is based on information derived from the records, and he has to identify what record, whether records of the plaintiff company or whatever is the other record, that he believes to be correct. Because please remember, if I ask you, each one of you, what are you doing today? You will say, we are watching a webinar. How do you say so? Because it is true to your personal knowledge, right? But tomorrow, if Gaurav were to send you a video, recorded video of this webinar, and say, please watch it, and you are watching it, this, you will say, is based on information derived from Gaurav's email, which I believe to be correct. So there is a difference. It's the same video. You are watching me, but when you are watching me in person on the webinar, it is true to your knowledge. But when you get a link which has this webinar, and then you start viewing that webinar, it is based on information that you have received, which you believe to be correct. So please remember this distinction while verifying your affidavits. So can we move to the next slide, please, Gaurav? Yeah. Now, having seen what all it should contain, there are certain don'ts also, which, in my view, should be kept in mind. They're very important. So as I mentioned at the very outset, no copy paste of pleadings, no reproduction of contents of documents. I've seen people will simply reproduce the entire agreement in the affidavit. You don't need to. If the agreement is admitted, that's the best thing. You don't need to say parties entered into an agreement dated so-and-so, the agreement is as under. Sorry, it's not required. Two, you can't lead evidence as to the contents of a document. The document itself has to be seen. You can't reproduce the contents of a document in your affidavit and believe that the document will be proved. No. Third, and which is very frequent, frequently seen in the affidavits, is affidavits contain submissions. I've seen affidavits relying on AIR 2015 Supreme Court or SCC 2016, etc., where the Supreme Court has said this or High Court has said this. It's a strict no. You have produced a witness to depose on facts. When it comes to submissions, you as the advocate are going to make submissions before the court. Witness is not going to make those submissions. Please remember, it is not the job or the role or the purpose of leading evidence that the affidavit should contain submissions. Witness is not supposed to and is not allowed to make those submissions. He's a witness of facts. So please cut out all your submissions from the affidavit in evidence. No opinions. Witness is speaking about the fact. I attended the webinar. He's not asked to give an opinion whether he liked the webinar or he disliked the webinar. That's not the point. The fact is whether a webinar was held, who was the speaker. That's all. It's not, you're not seeking an opinion when you file an affidavit in evidence. I'm not talking of expert with testimony here. I'm talking of a normal general affidavit in evidence. So no opinions. Because remember, witness is only deposing on facts. And last but not the least, please remember, it is the witness story that has to come in the affidavit and not the advocate story, not what the advocate thinks or has in mind. So that's all, friends, I wanted to share with you today in this webinar. I hope I made sense. Thank you very much.
Thank you so much, sir, for an informative session. I myself, I'm sure I've learned a lot. Before taking on questions, sir, we'll move on to you again, just for we have a lot of young lawyers here, and they have this question going on private chats. What will be your 5 cents of advice on how to kickstart a career in law for fresh law graduates?
Okay, so hard work, and hard work. Let me tell you, there is no shortcut to success. You need to put in your best. You have to be honest to the brief. You have to be fair. And that's all that you need in this profession.
Great. Thank you, sir. Ankit, if you could ask the questions.
So just to take up some of the questions that we've been receiving, Mr. Rajendra Arora has posed this question. Does it have to be mentioned in the affidavit that the witness will be deposing on such and such topics? So does the witness in the affidavit have to say that I will be deposing on these topics? That's the first question that we've received.
So, Ankit, that's a very valid question that Mr. Rajendra Arora has raised. As I mentioned, if you are dividing the testimony into different baskets, once you have assessed that we need to lead evidence on 3 aspects, there is a commercial aspect, there is an accounts related aspect, and there's a technical aspect. It's a good idea to set out at the very outset that I am going to speak on the commercial aspects, because one, the judge knows that this witness is only on the commercial aspects. The other side is put to notice that this witness is on commercial aspects. And when the other side is asking him questions on the technical aspect, he can very conveniently respond by saying that there is another witness on the technical aspect who's coming in and he will speak on those matters. I'm not really the right person. So it's a good idea to mention, the subject that he's going to be speaking about.
Right. I'll move to the next question, which we've received from Mr. Manu Sharma. Question is, and this is something that a lot of us do think about. Before the proceedings, can we prepare the witness? Can we tell him how to present his version? This is something that a lot of us do wish to know.
Sure, Ankit, what Mr. Manu Sharma has asked is, we all go through it. And, when you sit down to draft affidavit in evidence, as I mentioned in one of my earlier slides, that you interview the witness, you talk to the witness, and then let the story emerge from that witness. One of the advantages of doing that is that the witness is also being prepared to face cross-examination. Because when witness is sitting with you informally in your chamber, talking to you, you are putting him questions, you are also quizzing him, you are also cross-examining him. Now, he is being prepared to face a volley of questions when he would sit in the chair of the witness. And yes, it is important to prepare the witness. There's a difference between tutoring a witness and preparing a witness. So thankfully, the question was not on tutoring the witness, it was on preparing the witness. You need to prepare the witness, but the preparation starts when you sit down to draft the affidavit in evidence.
Thank you. The next one, and the next question is actually something that you and I have also had a debate on. This is from Mr. Ankur Mahindru. He asks, why do we need to have an authorization for a witness to depose?
So, okay. In case a witness is appearing for and on behalf of the company, and he's speaking partly from his knowledge and partly from the records of the company, unless he's authorized by the company, how can he say that I have had access to those records, right? Sometimes the records could be board minutes. Sometimes the records could be other sensitive information, which may not otherwise be normally available to him. So one, it serves that purpose that, yes, here is a person who's authorized by the company to have access to the records. Number two, when a person appears and produces an authorization, it also conveys to the court that yes, here is a person, I'm not saying that anybody else who does not prove authorization would be called an unauthorized witness. No, that's not the idea. But it conveys that yes, the company has considered this person to be the right person to depose in this matter. 3, it reduces a lot of cross-examination, because I have seen in my experience, witnesses who have not produced authorization, they've been asked several questions. Or were you authorized? You were not authorized? Have you met the board of directors? Who has asked you to come here? How did you get access to these board minutes, etc.? He may say, no, my company secretary gave it to me. But was company secretary authorized by board of directors? He would have no clue. So therefore, once you have given him an authorization and filed that authorization, it sets at rest a lot of unnecessary questions. So it's a good idea to produce that authorization in the court.
Thank you so much for that answer. I'll now request Gaurav to take this forward.
Thank you, Ankit. So we have a few more questions. One of them is from Rajat Bansal. He asks, what is the actual way to contradict a witness? If you could give a practical example, and how to record the same.
Rajat, I hope you're coming on the 13th webinar, because that's when I'll be speaking about cross-examination, where, there are certain techniques I would be sharing with all of you, once, because you said how to contradict a witness. Now, there are several ways of doing it, but it requires a lot of preparation. First, you need to be totally prepared. You need to have a complete overview of the matter, because please remember, when you're asking questions to a witness in cross-examination, every answer that he gives can be read against you also. So it's very important for you to know, the answer that he's going to give. 1. 2, when you said how to contradict a witness, now this is all fact dependent, in a given situation, what is it that the witness has deposed, and what material do you have in your hands to confront him? And there is a technique, I'll be sharing with you that technique on 13, because when I put that in that perspective, you would appreciate it better.
Great, thank you, sir. So there is a participant who would like to ask the question themselves. Raya, I'm unmuting you. Could you ask your question? Raya, could you ask your question? Looks like there's some technical. So we'll move to the next question. We have a question from Aishwarya Kumar Avasti. She asks, how to prove an email sent by a manager or the vice president of a company annexing charts and statements prepared by accounts department or other departments?
Gaurav, can you please repeat that?
Yes, sir. The question is, how do we prove an email sent by a manager or a vice president of a company annexing charts and statements prepared by accounts department or any other department?
So, Aishwarya, if the person, the manager or the vice president is appearing in the witness box, he will definitely bring a printout, or he would have filed a printout of that email with its annexures. And he would say that, yes, there is a printout of the email which has been taken by me. Remember the provisions of Section 65B of the Indian Evidence Act, or if it is a commercial dispute, provisions of Order 19, Rule 4 or Rule 6, amended by the Commercial Courts Act. Keep those ingredients in mind, and the author or the sender of the email can always prove the email that, yes, this is the email I had sent from my system. There is a printout, and he'll lay down the complete requirements of 65B. He can prove that.
Great, sir. Thank you. So the next question is by Raya Basu. It is WhatsApp chat accepted, and how can it be proved?
So Raya, WhatsApp chat is again electronic record. And today, you can take screenshots, you can take printouts and prove them with 65B. Of course, you will need to preserve the original. You can't say my WhatsApp is deleted from my system, from my mobile, But these are the printouts or screenshots I had taken the relevant time, because, how will you prove the sender or the receiver of a particular message? It just, you can configure anybody's number as Rajeev Virmani and say, this is the message I got from Rajeev Virmani. So that may not work. It's important to preserve the original media, original mobile, where the WhatsApp is stored. And you can then take the prints from the screenshot or prints of the screenshots and file them with 65B.
Great, sir. Thank you. Sir, following on to 65B, we have two more questions, 65B, and then I'll move on to further questions. It says in e-filing of an FIR, is it necessary to attach or annex a 65B?
You see, 65B is required at the evidence stage, right? When you're filing an FIR, to my mind, it is good enough if you annex the printout, if you annex, the copy of that electronic record. And at the stage of evidence, when evidence is led, that's the stage when 65B would be needed.
Great, sir. Thank you. Ankit, could you ask the next question, please?
Thanks, Gaurav. The next question that we have is, if a witness can speak from the record, will he be able to, for instance, attest to the truth of the correspondence addressed before he joined employment, since he's not really the author of that document?
So there are two aspects here, Ankit, what you have mentioned just now. One is the correspondence which pertains to the period before he joined. Now, obviously, if that correspondence is admitted by the other side, there is no difficulty in proving that part of the documentary record. But if that correspondence is disputed by the opposite side, then you will have to bring somebody on record who can, prove that correspondence. That's one. Second, the witness can definitely speak from the record if there is nobody who was contemporaneously there available with the company. But it will be an uphill task for him because he would not have known what actually transpired, at the time when the two parties were transacting with each other. So that's a dilemma which many times we find that companies face when, by the time the litigation matures for trial, people who were handling or who were on the field, on the job, have already left. But you have no choice but to bring somebody who will only, he can't say that the contract was signed in my presence or these negotiations took place in my presence, because he cannot really depose about it. He has not participated in those discussions. He can only say that these are the letters which were exchanged between the parties. I've got them from the records. Records have been maintained by the company in ordinary course of business. But, of course, you have various tools available to you. You give notice to produce to the other side, under Order 12 Rule 8 CPC, when it's a letter addressed by you to them. You need to exercise all those options available to you to prove the record. So you can prove the record, but that witness cannot really say what transpired at a given moment when he was not in employment, because that is not really based on his knowledge. It will only be hearsay, which will be inadmissible.
So I would take that to mean that being not an author, one cannot attest to the truth or veracity of the contents of what is written, but the fact of receiving or the fact of the acknowledgement of receipt being in the company's record is something that somebody coming in later on could also depose to.
Yes, you can depose to, but if the document itself is denied, authorship of the document is denied, then you will have to get somebody who can say that yes, this letter was actually signed by so and so. And or the other option is that you locate that person, summon him. In some cases, I have actually done that. Summoned an ex-employee of the company to depose on a particular aspect. So when I mentioned that you divide the transaction into different chapters, you will realize that if an employee has left, there is a small chapter you can assign to that employee and invite him to depose only on that small chapter, because you will have other people available to speak on the other chapter. So you will not have to rely on one person to give the entire deposition.
Thank you so much. The next question that we have is, and this seems to be one specific to DRT, says that question is from Mr. Amardeep Jaiswal, and the question is the process of drafting of affidavit of evidence in a proceeding before the DRT, is it the same as the process that you follow otherwise under CPC?
Yes, Amardeep, the process is the same. You know, what an affidavit in evidence should contain, the principles by and large are the same. You know, you need to keep those factors in mind. What are the facts you need to prove when you are drafting an affidavit in evidence? What are the documents you need to prove when you are drafting the affidavit in evidence? Because ultimately, the purpose that the affidavit in evidence serves is to prove those facts which are disputed, to prove those documents which are disputed. So whether you are in DRT, you are in arbitration, or you are in a civil court, it serves the same purpose, and you need to keep the same principles in mind while making out your affidavit in evidence.
Thank you. The next question that we have relates to, and this is a question from Prabhat Singh, who's a law student. He asks, or he says rather, that he's generally confused on hearsay evidence and would like to understand under what conditions hearsay evidence would be acceptable.
So, hearsay evidence is, you know, if I can tell you in Hindi, suni sunai baat. So, when your hostel warden wakes you up in the morning, early morning, and asks you, where was your next door roommate the last night, and you tell him कि मुझे अंकित विरमानी ने बताया था कि वो रात को हॉस्टल से बाहर था. Now you haven't seen that person going out of the hostel yourself. Somebody else told you that so and so was out of the hostel at night. Now when somebody else tell you something which you haven't seen yourself, is all hearsay. So that's what it is all about.
Thank you. Another question that we are getting is, could you please explain if the objection of not producing the certificate of 65B is not taken at the earliest stage when exhibiting the email, then can it be taken afterwards, for example, during final arguments?
So that's a very good question. It's important that objections as to any part of the affidavit or any other aspect of the examination in chief, be it relating to documents or any contents of the affidavit, should be taken at the time when the affidavit is being tendered. And, you know, except for maybe one or two objections which come to my mind, which are, for instance, if the document is insufficiently stamped, etc., or it's not registered, for instance, all other objections will stand waived if you don't take them at the time when the affidavit in evidence is being tendered.
Great. Thank you, sir. We have another question from Abhimanyu Chopra. He asks, in an arbitration, the rules of evidence are relaxed if one wishes to take a technical issue with email and, let's say, printouts in absence of section 65B, and the arbitrator doesn't agree to the same. What is the recourse?
So, Abhimanyu, yes, in arbitration, rules of evidence are relaxed. Strict rules of evidence are not applicable. And therefore, if you are really objecting to electronic record, you need to put in a lot of hard work during cross-examination, because I've seen that arbitrators will generally say that, has the email been fabricated? Or is it that, how do you say that this email was never received by you? But if it is an email which is not inter se the parties, but if it's an email addressed by the opponent to a third party, you certainly have a right to object to it, and they will then necessarily have to do more than just file the email to prove the contents of the email.
Great. Thank you, sir. So the next question is from Manoj Kumar Devedi. He asks, sorry, this we have taken. It's almost similar. We'll move on to the next question, sir. It is, in case of the sole proprietor is at default taxes, the accountant under him thinks it's not safe and leaves the company. Is the accountant still accountable to as equal as the proprietor for tax defaulting?
Okay, so this I think travels beyond the scope of this webinar. I'm not a tax lawyer, so I can't give you any advice on this aspect. But yes, as the general law stands, a sole proprietor is responsible for everything that happens in his business, whether it is an accounting entry or it is tax evasion or tax default. An accountant is only hired by him for the limited purpose of writing the books of account. But it's his obligation at the end of the day to ensure that whatever is written in the books of account is accurate. So he can't escape the liability. That's my view, a general view. I'm not a tax lawyer, so please don't take it as my advice.
Thank you, sir. And Neonon, you can always contact us. We have upcoming webinars on tax as well by some other speakers. So now we'll take up some questions from FB Live. We have plenty of questions there. So the first one is from Nimita Narayan. She asks, as arbitrators are not bound by rules of evidence strictly, is it possible for an arbitrator to waive the requirements for proof of electronic evidence? And how does the same benefit the proceedings?
So, Nimita, as you would have seen during arbitrations, we sit down at the procedural hearing stage itself, and the arbitrators lay down a complete elaborate process they're going to follow. And you can always waive the formal proof of electronic record. And you can say, yes, whatever is being produced will be read into evidence. The next question then would be about the contents, and that you will have to deal with and prove the contents in case they are disputed by the opposite side.
Great, sir. Thank you. The next question is by Ananda Mitra. She asks, what should one not do while drafting an affidavit in evidence?
So, Anindita, if you please remember the last slide that I shared. Gaurav, can you please put that? The last
yes,
but one slide.
I'll just do that, sir.
And can you also please circulate it to everyone for their benefit?
We'll definitely do that, sir.
Yeah. So please wait for a moment, Anindita, you will have the last slide, last but one slide.
So this seems to be some technical issue.
Okay, let me just see if I can do it.
Yes, sir.
No, somehow I'm not able to do it. But let me just quickly read it out to you. So what I had mentioned in my slide was certain don'ts which are important. One is no copy paste of the pleadings. So don't think it's an easy job. You will copy paste the plaint or the written statement and your affidavit in evidence is ready, bingo. The fees will come into your pocket. No. No reproduction of contents of documents. Affidavit cannot and should not contain submissions. Affidavit should not contain opinions generally. I'm not talking about the expert testimony, but normal affidavit should not contain opinions because witness is only deposing about facts. So these are some of the don'ts. Please keep them in mind.
Thank you, sir. So the next question is by Manu Sharma. He asks again, hearsay evidence is admissible in some cases. For example, borrowed money from B sued A for not returning and he admitted this to C. In this case, can the third person statement to whom the admission has been made by the person borrowing money is admissible?
So, yeah, Manu, that's a very tricky situation where hearsay evidence would be admissible because it all depends upon what the witnesses have said. If somebody has acknowledged to a third party that, yes, I had received money from A, and that third party, steps into the witness box and says, yes, he told me that he has received the money. It may not be a hearsay, strictly speaking, because he has heard it, as we say, from the horse's mouth. So hearsay is when somebody else says, that, I saw somebody else doing this, that, etc. And you've not seen it. But if somebody makes an acknowledgement in certain situations, that can be admitted in evidence.
Great, sir. Thank you. So the next question on FB Live is by Haresh Nanji. He asks how to draft an affidavit of evidence in a professional in contract breach matter.
Sorry, in contract?
Breach matters.
Okay. So, Harsh, you need to keep, the tips and the points that I shared in mind while drafting an affidavit in evidence, whether it's in a contractual matter or any other matter. I have discussed with all of you the general skills which are required, the general things that are to be kept in mind while drafting affidavits in evidence. You need to understand what are the facts you need to prove, cut out the facts which are admitted, keep the issues in mind, then find out, what are the different sections of the facts which are disputed. If you can, divide that amongst different persons, allocate the roles, of proving one set of facts to one person who specializes in that field, and then, see what are the documents relating to that particular field and make your affidavit in evidence. Of course, same principles will apply.
Great, sir. Thank you. So the next question is by Monima Khan. She asks, is the exhibit and to mark an evidence the same or are they different?
So when you are submitting your affidavit in evidence, you also have documents that have to be admitted in evidence, and the documents that are admitted in evidence are given the exhibit numbers. So you would have seen there is a series which is followed. If it is a plaintiff's witness who's producing the documents and exhibiting the documents, it will be called exhibit PW or PW1 if it's a first witness, PW1/1, PW1/2, or PW1/1, etc. So the exhibiting of the documents means the document has been admitted in evidence, but it is not the proof of contents of a document. If the contents are disputed, you will still need to prove that.
Great, sir. Thank you. And sir, now we'll take up the last question. It is from Raya Basu again. He asks, can you please explain how to handle the situation if the witness, after filing of affidavit in chief, moves back or reverts or retracts from his statement?
So, Raya, there could be situations when the witness is not available, he has left the company and he's not willing to come forward. That could be one situation. You can take the court's permission to substitute that witness. The court may permit it if you are able to satisfy the court of good grounds for substituting that witness. But if the witness is available and is not forthcoming in the witness box, it's too bad. It's a bad luck for you. So, choose the witness carefully, as I said at the very outset. When you're interviewing the person, you will know who's a confident person, who's not a confident person. So it a lot depends on how you select the witness, of course, within the limitations that I mentioned.
Thank you, sir. Sir, we just have, one last question, again from FB Live. This person asks, Ankit asks that how elaborate or concise should be an affidavit of evidence? Like, does it really depend on how elaborate? Let's say the plaint is 60 pages. Then how elaborate should the affidavit of evidence should be?
So affidavit does not depend upon the volume of paper book that you have or the number of pages you have in your plaint. If your plaint runs into 60 pages and mentions 10 facts, out of which 9 are admitted in the written statement, then you only need to prove 1 fact. So I'll give you an example. I did an international arbitration where we carried records in 3 suitcases and the affidavit of evidence was only 1.5 page. So, it's entirely, up to you how you sift through the papers, how you filter, identify what is admitted, identify what is not admitted, focus on that. And, your affidavit can really be very, very concise. It need not be very long affidavit. And please don't compare it with the plaint that if my plaint is 60, affidavit should be at least 30 or 90. No, that's not the yardstick at all. So please don't put that as a measure to see whether you have made a good affidavit or not. remember the things that I've shared with you today while making your affidavit and evidence, and you would realize that it is really not that big as you would assume it to be.
Great. Thank you, sir. Thank you very much for taking out time today. Thank you, Ankit, for taking out time today. And thank you all the participants to actually the session. We have another exciting webinar coming up with Rajeev sir itself on the 13th, which is a follow-up, which is cross-examination in civil and arbitration cases. I assure everyone that the same will be an exciting session, because there, sir will actually discuss a strategy of what to ask, what not to ask, how to ask, what type of questions to ask. It will be more of a practical aspect than just a talk. Thank you, everyone, today for joining us. Thank you, sir.
Thank you, Gaurav. Thank you, Ankit. And thank you, all the participants. You made my day. Thank you.
Thank you, everyone. Thank you.
We have other upcoming webinars. On 12th, we have a learned Metropolitan Magistrate who's speaking on victim compensation and victimology. He is the same judge who also recorded the controversial statement of the victim in the Nirbhaya gang rape case. And then we have again with us Geeta Luthra, senior advocate. Ma'am is speaking on evolution of rape laws in India and the aspects on what are we lacking today. Thank you so much, and keep tuned to Lawyers Club India for further updates. Have a great evening and stay safe.